Hello everybody, I'm delighted to be with you today for this webinar to discuss the SFC's latest consultation on a proposed code of conduct on book building and placing activities in equity capital market and debt capital market transactions, and the SFC's separate proposal on sponsor coupling. I'm going to begin today with an overview of Hong Kong's equity and debt capital markets and current market practices, followed by a summary of the SFC's concerns with respect to the book building and allocation process in Hong Kong. We'll then look at the SFC's proposed code of conduct provisions, the types of offerings and intermediaries they will apply to, and the standards of conduct that will be required. I'll close the webinar with a discussion of the sponsor coupling proposal and the SFC's rationale for proposing it. So on the 8th of February 2021, the SFC published a consultation paper with two main proposals. The first proposes new code of conduct requirements for intermediaries conducting book building and placing activities in equity and debt capital markets transactions. The second is a so-called sponsor coupling proposal, which would require at least one head of the underwriting syndicate or a company within the same group to also act as an independent sponsor of the IPO. The proposals followed a thematic review of certain SFC licensed intermediaries engaged in equity capital market or debt capital market Hong Kong book building and placing activities and discussions with market participants. That review apparently found that in some offerings, the price discovery process had been hampered by various factors such as inflated or opaque demand. The SFC also identified cases of what it considered to be undesirable intermediary conduct, such as brokers without a mandate swarming order books at the last minute with orders of what it refers to as unknown quality. The SFC's thematic review also identified good practices which it proposes to codify. Separately, the SFC identified that sponsors' fees and their costs and liabilities are often misaligned, particularly in larger IPOs. According to the SFC, this raises concerns that IPO sponsors may compromise their due diligence work to become the head of the underwriting syndicate and earn the much higher fees that come with that to make up their costs for acting as sponsor and the potential liability. The SFC is therefore proposing to impose various obligations on intermediaries involved in Hong Kong book building and placing activities in a new paragraph 21 of the Code of Conduct for persons licensed by or registered with the SFC. These intermediaries will be defined as capital market intermediaries and are sometimes referred to as CMIs, while the syndicate head is referred to as the overall coordinator or sometimes the OC. The SFC is also proposing that syndicate membership and fee arrangement should be determined early and that the capital market intermediaries and overall coordinators should be appointed under written agreements which set out their roles, responsibilities, and the fee arrangements. On IPOs, the sponsor coupling proposal will require that at least one overall coordinator must be appointed as a sponsor, and the sponsor must be independent of the issuer. The SFC's stated objectives in introducing the proposals are to address their concerns regarding intermediaries' conduct, to deal with issues arising from competitive pressures, and to align incentives with the responsibilities of intermediaries. The consultation closes on the 7th of May. Respondents' comments will then be considered and consultation conclusions will be issued together with a revised code of conduct and GEM placing guidelines. As market participants may need to update their internal controls and procedures to implement the new requirements, the SFC is proposing a 6-month transition period for the industry to comply following gazetting. Price discovery in Hong Kong is conducted by way of book building, which, when conducted transparently and fairly, the SFC thinks serves the interests of both issuers and investors. The SFC says in the consultation paper that competitive pressures have led intermediaries to engage in conduct which often tips the scale in favour of issuers. This, it claims, can distort the price discovery process and the allocation of equity and debt offerings. However, there are currently no specific conduct requirements for intermediaries involved in book building activities and placing activities. Through the thematic review, the SFC identified a number of concerns with the book building and allocation process. The SFC's first concern relates to the roles and functions of the various intermediaries involved in capital raising activities in Hong Kong, including heads of syndicates, other syndicate members and brokers. The SFC found that generally, written agreements entered into by intermediaries do not clearly set out their roles and functions, and that intermediaries' titles sometimes have little bearing on their seniority or responsibilities in relation to a transaction. With regard to syndicate membership, the SFC noted that some market participants have informed it that what it calls conventional appropriate issuer practices include appointing the heads of syndicate at the outset of transaction before kick-off and issuers treating the heads of syndicates as their trusted advisors on marketing strategy and the pricing and allocation. These market participants apparently also describe it as normal market practice for underwriting fees to be agreed at the outset of a transaction, and they should comprise a fixed fee for syndicate members' advice and preparatory work and the amount of the offering they're expected to sell, and a discretionary fee to incentivize sales performance. The consultation paper notes concerns that some issuers have deviated from these market practices by only determining fee arrangements and syndicate membership shortly before the publication of the IPO prospectus or shortly before book close on debt offerings. The concern is that allowing intermediaries to join the syndicate at the last minute means that they're not familiar with the issuer and unable to market the offering properly. In relation to incentive structures, the SFC found that while fixed fees have traditionally made up the largest share of underwriting fees, some issuers now allocate significantly more to discretionary fees. It's claimed that some issuers reward syndicate members for their ability to support very aggressive pricing, and that some syndicate members focus more on the quantity of orders than the quality of orders, particularly price-insensitive orders from corporate and individual investors. The SFC's concern is that price-insensitive demand can drive up the share price to a level desired by the issuer, but which cannot be sustained in secondary market trading, resulting in steep declines in post-IPO share prices and thin liquidity. The SFC's thematic review also determined that some intermediaries were knowingly placing inflated orders and overstating demand, which undermines the discovery process and can mislead investors. Another concern for the SFC is the apparent lack of transparency of the order book, which it says prevents syndicate heads from assessing real demand or identifying unusual or irregular orders. It's particularly concerned about the use of X orders in debt capital markets transactions, where investors' identities are concealed and known only to the syndicate members who place the orders and the issuers. The SFC's concerns include the use of X orders may result in unusual, duplicated, or potentially fictitious orders not being identified. Issuers may request X orders to conceal the identities of prospective investors with whom they're closely associated in order to inflate market-driven demand in the order book. Sell-side market participants sometimes use X orders to prevent other syndicate members from poaching their clients. And some investors, particularly sovereign wealth funds, may request X orders to conceal their participation in a debt capital market transaction. Conflicts of interest are another source of concern. The thematic review found that some syndicate members did not give priority to orders placed by their investor clients over their proprietary orders. The SFC is also concerned that syndicate members with access to the order book are privy to non-public information which they could use to increase their chances of allocation in popular deals, for example, by revising orders to make them more attractive than those of other investors. Preferential treatment or rebates paid to investors. In debt transactions, the SFC found that while rebates paid to private banks are not meant to be passed on to private banks' clients, this does happen. The SFC considers that this undermines the fair treatment of investors, as different investors, in effect, pay different prices for the same debt securities. In the equity market, the SFC noted cases of brokerage fees being rebated to IPO investors, effectively reducing the share price paid by these investors. The SFC found that heads of syndicate did not maintain records or maintained insufficient or inadequate records of incoming client orders. Important discussions with the issuer and syndicate members are the basis for making allocation recommendations, and the SFC's thematic review also identified some potential breaches of the stock exchange's requirements, including cases where syndicate members had attempted to allocate IPO shares to clients with which they were associated without seeking prior consent from the Hong Kong Stock Exchange. Turning now to the SFC's proposed code of conduct. The proposed code will regulate intermediaries conducting bookbuilding or placing activities in Hong Kong. Bookbuilding activities are defined as collating investors' orders, including indications of interest, in a share or debt offering to facilitate price determination and the allocation of shares or debt securities to investors, or the process of assessing demand and making allocations. Placing activities are defined as distributing shares or debt securities to investors pursuant to bookbuilding activities. The proposed code will also apply to intermediaries which advise, guide, and assist issuers in Hong Kong bookbuilding and placing activities. Intermediaries engaged in these activities will be referred to as capital market intermediaries. These don't include financial advisors or other professionals who advise the issuer, but do not participate in bookbuilding or placing activities. In terms of the type of offerings covered, the proposed code will apply to shares to be listed on the Hong Kong Stock Exchange issued by a listing applicant in an IPO, including a share offering in relation to secondary listings, offerings of shares of a class new to listing, and offerings of new shares of a class already listed under a general or special mandate. The proposed code will also apply to units or interests in SFC-authorised real estate investment trusts, listed or to be listed on the Hong Kong Stock Exchange, and shares listed on the exchange when a shareholder places its existing listed shares to third-party investors, followed by a top-up subscription of new shares by the shareholder, to the extent that these offerings involve bookbuilding activities. In terms of debt capital market transactions, the proposed code will cover all types of debt offerings involving bookbuilding or placing activities conducted by intermediaries in Hong Kong. These will include listed and unlisted bonds, bonds with complex features, bonds issued by sovereigns or corporates, bonds targeting retail or professional investors, and high-yield issues. The proposed code won't cover offerings which do not involve bookbuilding activities, such as bilateral agreements or arrangements between issuers and investors, such as club deals, transactions involving only one or several investors, where the terms of the offering are negotiated and agreed directly between the issuer and the investors, transactions where shares or debt securities are allocated to investors on a predetermined basis. The proposed code will also not cover a share offering which has been subscribed by an intermediary as principal, deploying its own balance sheet for onward selling to investors or otherwise. The proposed code will define the overall coordinator or OC as the head of syndicate for an offering, by reference to the activities it conducts rather than by its title. On a share offering, the overall coordinator is a syndicate capital market intermediary which solely or jointly conducts any of certain specified activities. The first includes the overall management of the share offering, coordinating the bookbuilding or placing activities conducted by other capital market intermediaries, exercising control over bookbuilding activities, and making allocation recommendations to the issuer. The second activity is advising the issuer of the offer price and being a party to the price determination agreement with the issuer. The third is exercising the discretion to reallocate shares between the placing tranche and public subscription tranche, reducing the number of offer shares, or exercising an upsize option or over-allotment option. And the fourth activity is acting as the stabilizing manager. In the case of a debt offering, an overall coordinator is a syndicate capital market intermediary which solely or jointly conducts the overall management of the debt offering. coordinates the book building or placing activities conducted by other capital market intermediaries, exercises control over book building activities, and makes pricing or allocation recommendations to the issuer. All other capital markets intermediaries will fall within the category of syndicate capital market intermediaries or non-syndicate capital market intermediaries, depending on whether they have a mandate and a direct relationship with the issuer or not. Examples of syndicate capital market intermediaries include book runners, lead managers, co-managers, and placing agents, while non-syndicate capital market intermediaries include, for example, sub-placing agents or brokers which only collate orders received from their investor clients. Turning now to the standards of conduct expected of capital markets intermediaries. These are set out in paragraph 21.3 of the proposed code and are baseline requirements with which all capital market intermediaries would have to comply. Paragraph 21.4 sets out additional requirements which only apply to overall coordinators. Let's look firstly at the proposed requirements on conducting an assessment of the issuer and the offering. The SFC found considerable variance in the scope and depth of capital market intermediaries' assessments of issuers and offerings, and noted the need for capital market intermediaries to gain a proper understanding of the issuer and the offering to market shares or debt securities to their investor clients. The proposed code will require that before engaging in an offering, a capital markets intermediary should take reasonable steps to obtain an accurate understanding of the issuer, which may vary depending on the type of offering and the role played by the capital market intermediary. This assessment should include obtaining a sufficient understanding of the issuer's history, background, business and performance, financial conditions and prospects, operations and structure. An exception is provided for a capital market intermediary for a debt offering which has been a capital market intermediary for a previous debt offering by the same issuer. In that case, the capital market intermediary should ascertain whether there have been any material changes in the issuer's circumstances of relevance to its role as capital market intermediary. To help CMIs assess the issuer and the offering, the SFC also proposes that an overall coordinator should share information about the issuer with the syndicate capital market intermediaries, or take reasonable steps to ensure that the issuer provides this information to them. This information should then be shared with non-syndicate capital market intermediaries. The proposed code will also require capital markets intermediaries to establish a formal governance process to review and assess the offering before entering into an offering. The formal governance process should review the offering and assess any actual or potential conflicts of interest between the capital market intermediary and the issuer and associated risks. This would generally involve designating a member or members of senior management to assess, for example, the structure of the offering, any actual or potential conflicts of interest between the capital markets intermediary and the issuer, and associated risks involved in participating in the offering, financial or reputational. Capital markets intermediaries will also be expected to maintain sufficient resources and have effective systems and controls in place to ensure that it can properly discharge these obligations. The proposed code will contain provisions on the timing of appointments of capital market intermediaries and overall coordinators, and the need for appointments to be made under written agreements which set out the fee arrangements. The consultation paper notes that underwriting agreements for share offerings and subscription agreements for debt offerings are typically entered into late in the offering process, usually when the price has been fixed and allocations to investors are finalized. These agreements do not generally define the roles and responsibilities of capital market intermediaries, and underwriting agreements for share offerings typically specify intermediaries' underwriting commitment, which does not necessarily correspond to their fee entitlement. In debt offerings, it is also the norm to appoint syndicate heads verbally without written agreements. The SFC is therefore proposing that before a capital market intermediary, other than an overall coordinator, starts any book building or placing activities, it must have been formally appointed by the issuer, or another capital market intermediary in the case of a non-syndicate capital market intermediary to conduct those activities under a written agreement. The written agreement will be required to clearly set out the roles and responsibilities of the capital market intermediary, the fee arrangements, including the fixed fees, as a percentage of the total fees to be paid to all syndicate capital market intermediaries, and the fee schedule. On a share offering, the overall coordinator will have to be appointed before it provides any services as overall coordinator, and in any event, no later than 2 weeks after the listing application is submitted to the Hong Kong Stock Exchange. On a debt offering, the overall coordinator must be appointed before it conducts any book building or placing activities. Overall coordinators will need to be appointed under a written agreement which specifies the overall coordinator's roles and responsibilities, the fee arrangements and fee schedule. The SFC is proposing that the overall coordinator of an offering should advise the issuer on syndicate membership, fee arrangements, marketing strategy and pricing and allocation. An overall coordinator will be required to ensure that its advice and recommendations are balanced and take into account the issuer's preferences and objectives with respect to pricing and prevailing market conditions and sentiment. The proposed code will require overall coordinators to ensure their advice is aligned with all legal and regulatory requirements. On a share offering, an overall coordinator will need to advise and guide the issuer and its directors on the Hong Kong Exchange's requirements for placings under Appendix 6 to the Main Board Rules and Chapter 10 of the GEM Rules, and take reasonable steps to ensure that they understand and meet those requirements. Overall coordinators will also need to ensure compliance with the specific requirements of an offering of debt securities listed on the Hong Kong Stock Exchange. Chapter 37 bonds, for example, can only be offered to professional investors. Overall coordinators will be required to explain the basis of their advice and recommendations, including any advantages and disadvantages. For example, overall coordinators should communicate their allocation policy to the issuer and explain the factors behind the allocation recommendations. Advice should be provided in a timely manner. Where an issuer decides not to adopt an overall coordinator's advice or recommendations in relation to pricing or allocation, or where an issuer's decision on a share offering may lead to a lack of an open market and inadequate spread of investors, or may significantly and negatively affect the trading of shares in the secondary market, the overall coordinator should explain its concerns and advise the issuer against making the decision. The overall coordinator should also document any final decisions of the issuer which deviate materially from the advice or recommendations provided by the overall coordinator, including the overall coordinator's explanation to the issuer of any concerns associated with the decisions and the advice provided. In the case of a share offering, the overall coordinator should report to the SFC any issuer decisions that amount to material non-compliance with the exchange's requirements on placings. The proposed code will require an overall coordinator to advise and assist the issuer in developing an appropriate marketing and investor targeting strategy, which should take into account the issuer's objectives and preferences. The strategy may specify the types of investors targeted and the proportion of an offering to be allocated to each type of investors to establish the desired shareholder or investor base. For IPOs, the strategy should also include the types of investors who may be appropriate cornerstone investors and aim to achieve an open market and an adequate spread of investors and promote the orderly and fair trading of the shares in the secondary market. An overall coordinator should also advise the issuer to adjust the strategy as appropriate in response to changing market conditions and sentiment. Overall coordinators should inform other syndicate capital market intermediaries of the marketing and investor targeting strategy, and syndicate capital market intermediaries would be required to inform capital market intermediaries they engage of the strategy so that it can serve as a basis for their selling activities. Capital market intermediaries should not market to investor clients falling outside the strategy. On a share offering, where the shares are only marketed to selected investor clients, capital market intermediaries should be satisfied that the shares are marketed to a sufficient number of investor clients to minimize the likelihood of an undue concentration of shareholdings. Investor clients who fall within the strategy but to whom the capital market intermediary does not actively market should have the opportunity to participate in an offering if they show interest. With respect to rebates and preferential treatment, it's proposed that CMIs should not offer any rebates to their investor clients or pass on any rebates provided by the issuer. In addition, on IPOs, capital market intermediaries should not enable investor clients to pay less for their shares than the total consideration disclosed in the listing document, including the 1% brokerage fee. On debt offerings, capital markets intermediaries should not enter into any arrangements which may result in investor clients paying different prices for the debt securities. A capital markets intermediary will be required to disclose to the issuer, the overall coordinators, all of its targeted investors and all non-syndicate CMIs it appoints, any rebates offered by the issuer to capital market intermediaries, and any preferential treatment of any capital markets intermediaries or targeted investors. On a share offering, a capital markets intermediary should make the disclosure on becoming aware of any rebate or preferential treatment. On a debt offering, disclosure should be made no later than the dissemination of the deal launch message to targeted investors. The proposed code will also impose an obligation on overall coordinators to disseminate the information they receive about rebates or preferential treatment to all syndicate capital markets intermediaries for their onward disclosure to targeted investors and the non-syndicate capital markets intermediaries they appoint. The overall coordinator will be required to advise IPO issuers against providing any arrangements which would allow investor clients to pay less than the total consideration disclosed in the listing documents. On debt offerings, the overall coordinator should advise issuers against providing any arrangements which would allow investor clients to pay different prices for the debt securities. The overall coordinator should also advise and guide the issuer in relation to the necessary disclosures. To ensure that investor clients fall within the categories identified by the marketing and investor targeting strategy, the proposed code will require capital markets intermediaries to take reasonable steps to assess each investor client profile, including their investment preferences and past investment history. This will be in addition to complying with the current Know Your Client requirements under paragraph 5.1 of the SFC Code of Conduct. Under the proposed code, a capital markets intermediary will be required to take reasonable steps to identify restricted investors. That's investors to whom the allocation of shares is either restricted or requires the prior consent of the Hong Kong Stock Exchange. Examples include connected clients and core connected persons. Capital markets intermediaries will have to inform the overall coordinator before placing an order on behalf of a restricted investor. The SFC further proposes that in order to facilitate the identification of restricted investors, overall coordinators should provide more information to capital markets intermediaries in respect of people and entities related to the issuer. This will require overall coordinators to obtain a list of these people or entities from the issuer and provide this to all capital markets intermediaries. An overall coordinator should also take reasonable steps to identify restricted investors so that they will only be allocated shares in accordance with the Hong Kong Stock Exchange requirements. In the case of debt offerings, the SFC proposes that a capital markets intermediary should identify whether its investor clients may have any associations with the issuer, the CMI, or a company in the same group of companies as the capital market intermediary. The overall coordinator will also be expected to provide sufficient information to capital markets intermediaries to enable them to identify these investors. The capital markets intermediary should inform the overall coordinator of these investors to enable the overall coordinator to assess whether any orders may negatively impact the price discovery process. The SFC considers capital market intermediaries to be responsible for ensuring that the price discovery process is credible and that the order book is transparent and incorporates only bona fide orders. An overall coordinator should ensure that the pricing and allocation recommendations made to the issuer fully take into account the principles and factors stipulated under the proposed code. The SFC has identified concerns regarding the use of X orders, where the identity of the investor is concealed. It therefore proposes to require the identities of all investors to be disclosed in the order book, except for orders placed on an omnibus basis. In the case of omnibus orders, the identity of the underlying investors will need to be provided to the overall coordinator and the issuer, but need not appear in the order book. Capital markets intermediaries will also be required to take reasonable steps to ensure that all orders placed in the order book on behalf of their investor clients, the capital markets intermediary itself and its group companies, represent bona fide client demand. Capital markets intermediaries must not place knowingly inflated orders. They should also make inquiries with their investor clients about orders which appear unusual and will be required to maintain adequate records of orders placed by their investor clients to substantiate that there are no fictitious or knowingly inflated orders in the order book. Regarding the overall coordinator's obligations, the overall coordinator will be required to ensure that the identities of all investor clients are disclosed in the order book, except for orders placed on an omnibus basis. If any orders appear to be unusual or irregular, the overall coordinator should make inquiries with the capital markets intermediaries. The OC is required to consolidate the order book by taking reasonable steps to identify and eliminate duplicated orders, inconsistencies and errors. It should also segregate and clearly identify in the order book any proprietary orders or capital markets intermediaries and their group companies. The SFC has noted observations by IOSCO that conflicts of interest between the issuer and the capital markets intermediary or its investor clients can lead to under or overpricing. The SFC also highlighted concerns regarding the impact of conflicts of interest on allocations of shares or debt securities, for example, cases of allocations being made to firms' most valued clients or to other parts of a firm's business. The SFC's thematic review further found that allocation recommendations were primarily based on the judgment of individual staff and their understanding of the issuer's objectives or preferences. Capital market intermediary allocation policies, where these existed, generally gave insufficient guidance to staff, particularly on potential conflicts of interest. The SFC also found that documentation of allocation decisions and their rationale was generally insufficient to demonstrate compliance with an allocation policy and appropriate management of conflicts. To address these concerns, the SFC proposes that an overall coordinator should discuss with and advise the issuer on the final offer price, taking into account the results of book building activities, the issuer's characteristics, and prevailing market conditions and sentiment. In the case of debt offerings, the overall coordinator should ensure that the orders placed by investors which have associations with the issuer, capital markets intermediaries and their group companies will not negatively impact the price discovery process. In line with the IOSCO recommendations, the SFC further proposes that an overall coordinator should develop and maintain an allocation policy which sets out the criteria for making allocation recommendations to the issuer. The allocation policy will be required to take account of the issuer's objectives, preferences or recommendations, prevailing market conditions and sentiment, and targeted investors' type, characteristics and circumstances, such as clients' financial profiles, investment experience and objectives. It should also address the spread of investors, such as the sizes and numbers of large holdings and the overall subscription rate for the offer. An overall coordinator should communicate the allocation policy to the issuer early to ensure that the issuer understands the factors determining allocation recommendations, and an overall coordinator's allocation recommendations should be made in line with the policy. In the case of an IPO, allocation recommendations should ensure that allocations to restricted investors comply with the exchange's requirements and be made with a view to achieving an open market, an adequate spread of shareholders, and promoting the orderly and fair trading of shares in the secondary market. The overall coordinator should also document allocation recommendations provided to the issuer, including its rationale. Capital markets intermediaries will also need to establish and implement an allocation policy to ensure a fair allocation of shares or debt securities to their investor clients where they place an order on an omnibus basis, and an overall coordinator gives them an overall allocation. The policy should set out, for example, the marketing and investor targeting strategy agreed with the issuer, investor clients' order sizes and circumstances, price limits for clients' orders, any minimum allocation amounts indicated by investor clients, and any applicable legal and regulatory requirements. Capital markets intermediaries should allocate shares or debt securities to investor clients in accordance with the allocation policy and document any reasons for material deviations from the allocation policy. When allocating shares or debt securities, a capital markets intermediary is expected to assess whether the investor client has the ability to take up the allocation and whether the size of the order appears unusual. This also applies to an overall coordinator when making recommendations to the issuer regarding allocations of shares or debt securities to its own investor clients. The consultation paper expresses concerns relating to conflicts of interest where capital market intermediaries or their group companies place proprietary orders in the order book. The concerns include that capital markets intermediaries could take advantage of non-public information in the order book when placing proprietary orders to increase their chances of allocation, or unpopular offerings may allocate more shares or debt securities to their proprietary orders than to their client orders. The proposed code will therefore require capital markets intermediaries to establish and implement policies and procedures to identify, manage, and disclose actual and potential conflicts of interest with investor clients, which may arise when the capital markets intermediary has a proprietary interest in an offering. A capital markets intermediary will also be required to implement policies governing the process for generating its own proprietary orders and making allocations to those orders. The proposed code will also require CMIs to give priority to investor clients' orders over their own proprietary orders and those of their group companies. A capital markets intermediary will also be required to be a price taker in relation to its proprietary orders and those of its group companies, and should ensure that these orders are based on market-driven demand and would not materially influence the pricing of the offering. Proprietary orders placed by a group company will exclude those placed on behalf of clients or funds and portfolios under its management, but will include orders placed on behalf of funds and portfolios in which the capital markets intermediary or its group companies have a substantial interest. The overall coordinator and capital market intermediary should also segregate and clearly identify in the order book and book messages its own proprietary orders and those of its group companies, other capital markets intermediaries, and their group companies. The proposed code also stipulates that on debt offerings, a capital markets intermediary should take reasonable steps to disclose to the issuer why any risk management transactions it intends to carry out for itself, the issuer, or its investor clients would not affect the pricing of the new offering. The SFC proposes that the senior management of a capital market intermediary should review and approve certain types of orders and allocations, including proprietary orders of the capital market intermediary and its group companies. Orders from investor clients which appear unusual, for example, orders appearing to be related to the issuer and allocations to restricted investors in the case of share offerings. According to reports by IOSCO, capital market intermediaries should provide a range of information to investors in share or debt offerings to set the parameters for price formation during the book building process. The SFC is therefore proposing that a capital markets intermediary should disseminate material information relating to the offering to the OC, its investor clients, and the capital market intermediaries it appoints. Capital markets intermediaries should thus provide information about restricted investors for a share offering. On a debt offering, capital markets intermediaries should provide information about investor clients which have associations with the issuer, CMIs and their group companies. Capital market intermediaries will need to provide the information to the overall coordinator and non-syndicate CMIs appointed by them to enable them to properly discharge their duties. The proposed code will also require capital markets intermediaries to disseminate the marketing and investor targeting strategy to non-syndicate CMIs to facilitate their marketing of the shares or debt securities to investor clients. CMIs should also provide book messages and other information related to the offering, such as information on rebates offered to CMIs to the OC, non-syndicate CMIs they appoint, and to their targeted investors. OCs and CMIs should disseminate information in a timely manner and ensure that it's complete, accurate, and has a proper basis. The proposed code will require a CMI to maintain books and records to evidence the work done throughout the transaction and demonstrate compliance with the legal and regulatory requirements and the CMI's internal policies and procedures. CMIs will be required to document key communications with the issuer, investors, and other CMIs, and the basis of allocation decisions with justifications for any material deviations from the CMI's allocation policy. The records should also include an audit trail from the receipt of orders through to final order allocation. OCs will also be required to document all changes in the order book throughout the book building process, and all key discussions with and key advice or recommendations provided to the issuer. General Principle 3 of the SFC's Code of Conduct requires an intermediary to have and effectively employ the resources and procedures which are needed for the proper performance of its business activities. The proposed code will set out specific requirements for CMIs. First, the proposed code contains requirements for Chinese walls for a CMI, which is a company or part of a group of companies that undertakes multiple activities in relation to an offering. For example, research report preparation, book building, placing, and sponsor work. These CMIs will be required to take adequate measures to prevent the flow of information, which may be confidential or price sensitive amongst staff performing different activities, and to prevent and manage any conflicts of interest which may arise. In particular, CMI should maintain effective Chinese walls and wall crossing procedures and policies. The SFC is also proposing that when a CMI appoints a non-syndicate CMI, that is a sub-placing agent, it should exercise due skill, care, and diligence in selecting and appointing the non-syndicate CMI, which will require the CMI to take reasonable steps to ensure that the non-syndicate CMI is able to comply with the proposed code. This may require the CMI to review the non-syndicate CMI's marketing strategy and assess how it ensures that all investor clients, which are targeted investors and have indicated an interest in the offering, are allowed to participate in the offering. The CMI will also need to review the non-syndicate CMI's process for assessing whether investor clients are independent from or associated with the issuer and its procedures and controls to ascertain whether all orders are bona fide. The CMI would also be expected to review the non-syndicate CMI's allocation policy to ensure that it addresses the requirements under the proposed code and the procedures to ensure that allocation is made in compliance with that policy. The proposed code will also require CMIs to conduct independent surveillance and monitoring on a regular basis to detect irregularities, conflicts of interest, and leakage of price-sensitive or confidential information, and any potential non-compliance with applicable legal and regulatory requirements or their own internal policies and procedures. Owing to concerns from a number of buy-side and sell-side participants regarding fluid syndicate membership and fee arrangements, the proposed code will require fee arrangements to be specified in the written agreements with CMIs and overall coordinators will be required to advise issuers on the fee arrangements. The SFC does not, however, consider this sufficient to address what it considers to be a root cause of undesirable intermediary behaviour. The SFC considers that the determination of syndicate membership and fee arrangements at an early stage of an offering would allow OCs and CMIs to better focus their efforts and resources on providing advice to the issuer and conducting Hong Kong bookbuilding and placing activities in compliance with the proposed conduct requirements. It further expects that this would improve the transparency and credibility of the price discovery and allocation process. The SFC also notes that early agreement of fixed fees is consistent with international market practice, including in the US and the UK. Under the proposed code, the fixed fees payable to the overall coordinators should be determined at the time of their appointment, and these should cover the advisory services provided by an OC and proportions of shares or debt securities ordinarily expected to be sold by the OC. The issuer can subsequently appoint other syndicate CMIs and at the time of their appointment determine their fixed fees based on the volumes they're expected to sell. The SFC clarifies that issuers can still pay CMIs discretionary fees to incentivize sales outperformance. The SFC further states that it considers it appropriate for the ratios of fixed fees to discretionary fees and allocations of fixed fees to syndicate members to be agreed at an early stage. The SFC therefore proposes that each written agreement to be entered into by an OC or CMI should specify the fee arrangements, including the allocation of fixed fees to the particular CMI as a percentage of the total fees to be paid to all syndicate CMIs, and the fee payment schedule. The proposed code will also require an OC to advise and guide the issuer on fee-related matters and specifically on determining the ratio of fixed to discretionary fees to be paid to syndicate CMIs and the basis of allocation of fixed fees to syndicate CMIs. OC should also advise issuers on the basis of allocation of any discretionary fees to syndicate CMIs. In the case of a debt offering, this allocation should be determined no later than at the time of pricing. OCs will also be expected to advise issuers on the fee payment schedule. The SFC further proposes that certain information should be submitted to the SFC 4 clear business days before the listing committee hearing for an IPO. Information about the syndicate members indicating their roles, the total fees to be paid to all syndicate CMIs, the ratio between the fixed and discretionary portions of the fees to be paid to all syndicate CMIs in percentage terms, and the allocation of the fixed portion of the fees paid by the issuer to each syndicate CMI participating in the offering. The SFC clarifies that issuers may alter the fee allocations as an IPO timetable progresses. However, the SFC should be informed of any material changes once they are agreed between the issuer and syndicate CMIs, and of the reasons for the change. As regards discretionary fees, the SFC proposes that a confirmation should be provided to the SFC no later than listing that the issuer has determined allocations of any discretionary fees to each syndicate CMI as well as the fee payment schedule. Total monetary benefits, including fixed and discretionary fees, and any bonuses paid to each syndicate CMI by the issuer should be provided to the SFC within 2 weeks after the first day of dealings. Additionally, it's been noted that some market participants are in favour of issuers making public disclosure of the names of syndicate members and OCs at an early stage. These participants also support public disclosure of all underwriting fees for the IPO transactions, which are disclosed in the prospectus for the Hong Kong public offer tranche, but infrequently disclosed for the international placing tranche. Some market participants are in favour of public disclosure of the total monetary benefits, including fixed and discretionary fees and any bonuses paid to each syndicate CMI after the completion of the IPO. Turning now to the sponsor coupling proposal. This would require that on IPOs, at least one overall coordinator should also act as a sponsor which is independent of the issuer, or be in the same group of companies as a sponsor which is independent of the issuer. The SFC perceives there to be advantages where heads of syndicate also act as IPO sponsors, primarily due to the extensive knowledge sponsors gain about issuers during the due diligence process. However, a number of syndicate heads which did not act as sponsors increased in the first 9 months of 2020 compared to 2018. The SFC also points to a misalignment between the fees paid to sponsors and sponsors' costs, which can be substantial, and potential liabilities. Sponsor fees are generally substantially lower than underwriting fees. In the 9 months ended 30th of September 2020, the average sponsor fee was 6.3 million Hong Kong dollars, while the average underwriting fee was 43.9 million Hong Kong dollars. According to the SFC, where the sponsor also acts as the head of syndicate, the total fees may properly compensate the sponsor for its sponsor work and potential liability as sponsor. Conversely, if sponsors are not appointed as head of syndicate, the SFC is concerned that they may compromise their due diligence. It's worth noting that this idea that the problem of artificially low sponsor fees and concerns about sponsors skimping on due diligence could perhaps be solved by requiring sponsors to act as heads of syndicate is completely at odds with the thinking behind the sponsor regime introduced in 2013. The SFC's 2012 consultation paper on sponsor regulation also recognized that sponsor fees often did not reflect the amount of work required to be a sponsor. The solution was then for sponsor fees to properly reflect the amount of work required. The consultation conclusions stated that sponsor fees should appropriately reflect the role and responsibilities to be discharged by a sponsor and should not be confused with other services, notably book building, pricing, and similar functions governed by underwriting and related agreements. According to the consultation paper, the SFC's soft consultations found that market participants opposed proposals to require all OCs to be sponsors based on concerns that it would limit the issuer's flexibility in appointing OCs whose strengths are primarily in marketing rather than sponsor work. Similarly, the proposal could prejudice standalone boutique sponsor firms with no marketing capabilities. According to the consultation paper, 72% of IPO sponsors acted as syndicate members in 2020. The SFC's proposals could disadvantage these smaller boutique sponsors, while they are often very competent as sponsors. If they lack underwriting capability, they will be prevented from acting as overall coordinators. They could be appointed as co-sponsors, but this would require the issuer to pay double the sponsor's fees. The SFC is proposing that a listing applicant should appoint at least one sponsor which is independent of the listing applicant, who would also be appointed as an overall coordinator, or have a group company which is appointed as an overall coordinator for the IPO. This role is referred to as the sponsor overall coordinator. The test for sponsors' independence is set out in the listing rules. The sponsor overall coordinator will need to be appointed as overall coordinator and sponsor at the same time, and at least 2 months before filing the listing application. The listing applicant can appoint other overall coordinators, which may or may not be sponsors of the IPO, no later than 2 weeks after the submission of the listing application. The SFC hopes that the proposals will ensure that at least one sponsor will be free of potential incentives to limit due diligence in order to secure an OC role, and the sponsor OC will be in a position to give comprehensive advice to the listing applicant throughout the transaction. A further aim of the SFC is that buy-side participants will be able to look to the sponsor OC to provide well-informed and authoritative answers to their questions. The proposed code will require that before accepting an appointment by the issuer to act as an OC should either ensure that it or one of its group companies is also appointed as a sponsor, which is independent of the issuer client, and that both appointments are made at the same time, at least 2 months before the submission of the listing application to the exchange. Obtain a written confirmation from the issuer that at least one sponsor, which is independent of the issuer client, or one of the group companies of that sponsor, has been appointed as an overall coordinator for that IPO. The overall coordinator's appointment should be made no later than 2 weeks after the submission of the listing application to the exchange. The SFC is also proposing to revise paragraph 17 of the SFC Code of Conduct, which applies to sponsors. Before accepting an appointment by a listing applicant to act as a sponsor should either be independent of the listing applicant and ensure that it or one of its group companies is also appointed at the same time as an overall coordinator in connection with that listing application. It should obtain written confirmation from the listing applicant that at least one sponsor, which is independent of the listing applicant, or one of the group companies of that sponsor, has been appointed as an overall coordinator in connection with that listing application. The sponsor overall coordinator would also be expected to submit information on syndicate membership, the total fees to be paid to all syndicate CMIs, and the allocation of fixed fees as required under paragraphs 21.3 and 21.4 of the proposed code within the prescribed timeframe. If more than one intermediary is appointed as a sponsor OC, they should arrange for one of them to provide this information to the SFC. However, each sponsor OC will be jointly and severally liable for ensuring that the information is accurate and complete and has been provided to the SFC within the stipulated timeline. In terms of the impact of the proposed changes, there are different views, depending on who you speak to. The concerns that the bulge bracket banks have, who offer the full range of services from acting as IPO sponsor and underwriting, are different to those perhaps of some of the boutique sponsor firms, which don't have underwriting capabilities. The issues on mega hot issues, which are many times oversubscribed, are often very different to those on smaller companies, particularly those listing on GEM. On the issue of the OC acting as the advisor to the issuer, some banks are concerned about liability. There was a case in the US, EBC1 Inc. against Goldman Sachs, which held that the underwriter had a fiduciary duty in advising the issuer on its IPO. Following that case, US underwriting firms developed a practice of adding a clause to their underwriting agreements requiring issuers to acknowledge that they're not relying on the underwriters for financial advice. The concern for US banks then is that their capacity as underwriters and global coordinators rather than as sponsors, the SFC will require them to act as advisors to the issuer and take on liability which they normally seek to exclude. On the sponsor coupling proposal, a key issue is that this seems to be at odds with the aim of the 2013 sponsor regime. The SFC's focus then was on ensuring sponsor independence, which was thought necessary to ensure the objectivity of the sponsor's due diligence. The SFC's original proposal was that there should be only one IPO sponsor, which would have to be independent of the issuer, or if there were multiple sponsors, that they should all be independent. Ultimately, the SFC agreed that only one sponsor needed to be independent. There are a couple of potential issues with the sponsor coupling proposal. The first is the potential conflict of interest between the overall coordinator as the lead underwriter and the issuer. As the consultation paper says, the IOSCO report on conflicts of interest in equity capital markets highlighted the risk of IPO underpricing due to the inherent conflict of interest between the underwriters and the issuer. While it's in the issuer's interests for the share price to be as high as possible, it may be in the underwriter's interest to underprice the offering to increase the chances that all the shares are subscribed by investors and minimize the chances that they will have to purchase the unsubscribed shares. Given that inherent conflict, there is an argument against the overall coordinator advising the issuer on price. Underpricing of IPOs is not, however, addressed in the consultation paper, which notes the SFC's concern that competitive pressures between brokers has, in the SFC's words, tipped the scales in favor of issuers. In addition, sponsor coupling could be particularly problematic on deals where there's only one sponsor or only one independent sponsor. If an overall coordinator decides it no longer wants to underwrite an IPO, there is currently no problem. The issuer can appoint a replacement OC with no consequences for the listing timetable. However, if an OC which is either the sole or the only independent sponsor, a new listing application will need to be submitted because of the listing rules requirements that sponsors are appointed at least 2 months before the submission of the listing application. This could cause a substantial delay in the listing and additional costs and could effectively allow an OC which is the sole or sole independent sponsor to hold the issuer to ransom when it comes to agreeing the pricing. In not addressing the inherent conflict between the OC and the issuer, there are concerns that the sponsor coupling proposals risks exacerbating the position in entrenching the conflict where the OC is the sole or sole independent sponsor. Some have suggested that IPO issuers should instead be advised separately by an independent financial advisor on matters such as pricing and allocation. This would enable issuers to receive impartial advice and put them in a proper position to agree the pricing and the conduct of the distribution of the shares. The sponsor coupling proposal will also disadvantage boutique sponsor firms which do not have underwriting capabilities. In theory, these firms could be appointed as joint sponsors, but in practice, issuers may be unwilling to pay more than one set of sponsor fees. The sponsor coupling proposal would thus effectively preclude these boutique sponsor firms from acting as IPO sponsors. The SFC sees the sponsor coupling proposal as a means to address its concern that sponsors may compromise their due diligence inquiries to win the lucrative role of syndicate head, for which they generally face fierce competition from non-sponsors. Part of the answer to that concern could be to ensure that sponsors are properly compensated for their work and potential liability as sponsors. Although the SFC commented in its 2012 consultation conclusions on the sponsor regime that sponsors' fees should reflect the sponsor's role and responsibilities, no provision to that effect was in fact included in the Code of Conduct. This concern regarding sponsors potentially skimping on their due diligence could perhaps be addressed by making the requirement that sponsor fees properly reflect the work and potential liability of the sponsor under paragraph 17 of the Code of Conduct. The SFC also has ample means at its disposal for dealing with sponsors which conduct inadequate due diligence, and there are many examples of the SFC bringing disciplinary proceedings against sponsors on that basis. On the issue of early appointment of overall coordinators and early fixing of fees, there are different views depending on the type of deal you're talking about and who you talk to. For the bulge bracket banks working on large IPOs, they're keen to have everything locked down as early as possible. They, and also some on the buy side, are in favour of knowing who the overall coordinators are and what their fees will be as early as possible. They see it as unfair that a bank can join the syndicate late and take a share of the fees because it's bringing in a large cornerstone investor without putting in the work to understand the issuer and its business. By setting the syndicate fees early, the SFC is seeking to prevent what it describes as brokers swarming the order book at the last minute and bringing in large price-insensitive orders. For the banks working on smaller deals, particularly GEM IPOs, however, they envisage problems with the proposal that information about syndicate membership and the fees for the deal will have to be given to the SFC 4 clear business days before the listing committee hearing date. On smaller deals, underwriters are often unwilling to commit until there's some certainty that the deal will go ahead. There's also the problem that notice of listing committee meetings is often only given on Mondays for a Thursday hearing, which leaves very little time to conduct pre-marketing and get the syndicate in place. So there are a number of different issues which are extremely difficult to reconcile through a single set of requirements which apply across the board. So that brings us to the end. Thank you again for joining us today. We have some further webinars planned on the Hong Kong Exchanges consultation on the listing of overseas companies, and separately on the Hong Kong Exchanges consultation on changes to the corporate governance code and related listing rules. You'll find information on these upcoming webinars on our website from next week, charltonslaw.com. So I wish you all a very happy weekend. Bye.